And in the decisions that were made today, the 7 of them, and for layman it's quite straightforward: multiple choice referendum, IEBC quorum, and whether it had public participation. You had your questions about that and whether it was really pronounced on it. Civil proceedings against the sitting president, 70 constituencies being introduced, and the popular initiative being led by the president. But there's one thing that sticks out, and that is a doctrine of basic structure, or structure, however you would word it as a legal mind. What is this?
You know, this doctrine of basic structure, to be honest, is something that has come to the tongue of Kenyans as a result of the judgment of the High Court. The basic structure doctrine had been referred to earlier in a case called the Enjoyer case about 2005, in the run-up to the first referendum to amend the Constitution of Kenya, which was abortive. It did not succeed. And the basic structure doctrine has this core idea that the Constitution is like a house, and this house is built upon certain foundations and certain pillars. And that core structure of the house cannot be changed if you want to still have the house standing. You can change some of the rooms, you can expand the house, you can adjust certain aspects of the design, but there are these core foundations and pillars that cannot be touched. Otherwise, you have a completely different building. You have to first bring down the house and then construct a new house. So the idea of the basic structure doctrine was to say that within the Constitution, there are certain provisions that cannot be touched. They cannot be amended. They were being called at times eternity clauses or unamendable provisions. And I think the argument was whether Article 255 of the Constitution, which lists about 10 entrenched areas, provisions that are entrenched and require a referendum to be amended, whether Article 255 was sufficient in protecting the core structure of the Constitution of Kenya. And the High Court judges said that no, beyond what Article 255 says, that you have entrenched clauses that require a referendum to amend, you also have additional provisions in the Constitution which form part of the basic structure. The judges were asked, what are those provisions? And they said, we cannot give an exhaustive list. We can give an example. So, of course, this caused a bit of concern to close analysts of the Constitution, because if you can't tell what is the basic structure today, it means any future attempt to amend the Constitution, you'll never know whether you're amending basic structure. As a lawyer, can you advise your client that you are able to amend this provision or not this other provision? So that was a bit of the weakness with the basic structure doctrine. This doctrine was traced back to a 1977 Indian case called the Kesavananda case, which was a case where the Supreme Court of India was trying to protect the Indian Constitution from mutilation by Parliament, because the Indian Constitution had a solely Parliament-driven process of amendment. There was no popular referendum, etc. This was the case with Kenya's independence constitution until 2010. But in 2010, we developed a modern constitution which already provides for referendum in the case of certain amendments of entrenched provisions. So the core argument was whether Article 255 of the Constitution was sufficient to protect the basic structure and those various steps that you have to follow, or whether we needed to still import the basic structure doctrine. And the ultimate conclusion of the Supreme Court judges is we do not need the basic structure doctrine. Some judges said that we still have the basic structure, but we don't need that doctrine with those 4 sequential steps of constituent assembly, etc. When you are amending the Constitution, it is enough to follow the Article 255 constitutional provisions, which require you to have a popular referendum at the end of the process, whether you use a parliamentary process or a popular initiative. Once you are done with that process, go to a referendum and get the Kenyan people to decide whether they accept or reject that constitutional amendment.
So it doesn't necessarily block any attempt later at changing, even with the eternity clauses, at amending the Constitution.
So I can say unequivocally that the judgment of the Supreme Court is to the effect that any provision of the Constitution of Kenya is capable of amendment, so long as you follow the process in Article 255, 256, and 257 of the Constitution.
All right, and let me revisit a tweet here, again, Ahmed Nasir, Senior Counsel, you'll forgive me, but you also like to tweet on current affairs. This is to someone that has been named as a loser in this verdict. Raila Odinga, he tweeted earlier today, and he said, "We will not stop deliberations on the way forward that will decide on a future course of action that protects the interests of all those who voted to see the amendments come to light. For now, we have an election to win." How would you advise as they deliberate?
First, let me just revisit what my learned friend says, because he really put very well, what the basic structure is. But I think the flip side of the court's judgment today was that that judgment made the constitutional amendment under the 2010 Constitution to be actually as simple as the amendments that President Kenyatta won or Moi could take into old Constitution. If it wasn't the courts that stopped this process, I mean, President Kenyatta and Raila could have amended the Constitution yesterday.
Yes.
So that is the flip side of this jurisprudence that emerged. And I agree with them. It's very difficult, to read the basic structure doctrine in the text of the Constitution. It's very difficult. I mean, you can't really justify it, although it is a very intoxicating, very attractive, jurisprudential concept that can, when you argue it, you fly with it. Eh? Mm-hmm. But I think the court was right when they said you can't read such, a concept into,
yes.
Into a written constitution. Coming back to Raila, I mean, politicians are politicians. Even when they have even when you knock them down in the first round, they will wake up and declare victory. And I think basically that's what the Honorable Prime Minister is saying. I mean, this was knocked down, technical knockout in round one. And when he says, for example, he talks to all those people who voted.
Yes.
Who voted for this?
They put a figure of 4.3, and then it said that the IBC verified 1 million.
Nobody voted for this. I mean, this is a construct of, I said many times, a construct of two individuals, bulldozed everybody, bet everybody to submission. And they will today the Constitution will have been amended if it wasn't for the courts that stopped it.
Right.
Yes.
Professor, this is something that will be exciting in your class moving forward with your students, the University of Nairobi and elsewhere. This is setting a precedent, if that's what you call it professionally. And for you moving forward, how does this shape any attempt at amendments to the Constitution?
At the start of this show, I made the statement that the BBI bill is dead, but constitutional amendment is not dead. Yeah. And I think the answer that has been given demonstrates why that is so. Mm-hmm. Because at the heart of the issues were just two. The rest were other issues. At the heart of the issues was basic structure vis-a-vis the role of the president. And I think on the role of the president, all the courts are clear. The president cannot get involved. On the basic structure, the High Court and the Court of Appeal said you cannot touch the basic structure of the Constitution. What that would have meant is as long as everything that was being proposed in that document was said to be basic structure, you could never introduce them in any other way unless you went through a constituent assembly. I think by the court saying that, the basic structure cannot be read into our Constitution, it therefore means that if tomorrow, politically not possible, but if maybe a year, 2 years down the road, somebody says, I want to amend the Constitution to deal with the question of 35% to counties. It is possible to do so as long as you end up with what Article 257 and 255 provide, as long as you end up in a referendum. That of the 10 things, if you want to do so, end up in the referendum. On other things, if it is not any of those 10 things, you'd have to go back to Parliament. So there are several things that I think it means. One is that the bill and the issues in it, if you bring it back, you have to deal with the political consequences. But the issues, if you pick and choose and determine these issues I think are critical to the country and debate them, it is possible to do so. I think that the next thing that is critical for us is from a jurisprudential perspective, and I think there was a lot of debate about jurisprudence, about precedent. I think there's a lot of interesting discourse that arises out of this Constitution, out of this judgment, including the questions about, so what is the limits of the rights of, what's the limits of what Parliament can do, what's the limits of what the President can do, what's the limits of what citizens can do, and what's the power balance that's required out of them. So I think for me, those are the interesting things that arise out of this judgment.